We'll start with him. On the record in the matter, the people of the state of Michigan versus Malachi Kelly. This is file number 22-01963, FY council appearance.
Chris Martin for the people.
Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Kelly.
Okay, Mr. Kelly, can you hear us?
Yes.
Thank you. Today was the date that was scheduled for a preliminary examination. My understanding is that there is going to be an unconditional waiver to the circuit court. Is that correct?
That's correct, Your Honor.
Yes, Your Honor.
Okay, was there an offer on this?
Essentially, the offer is for Mr. Kelly to plead guilty as charged with a Killebrew agreement to no upfront jail at the time of sentencing, and the people have no objection to treatment under HYTA status.
Mr. Goodrich?
That is the defense's understanding as well, Your Honor.
Okay, Mr. Kelly, do you understand that you have a statutory right to have a preliminary examination here in the district court?
Yes.
You understand that at the time of your examination, you have the right to have the prosecution put forth sufficient evidence to establish that there's probable cause that exists, that a crime was committed and probable cause sufficient to charge you as the defendant who committed the crime?
Yes.
Do you wish to unconditionally waive your examination today?
Yes.
Okay, so that means you can't come back later and decide that you want to have your exam. Once you waive it, this matter will be bound over to the circuit court for further prosecution. And you will not have any hearing here at the district court level for evidence to be put on to establish sufficient probable cause. You understand that?
Yes.
Anybody threatening you to get you to waive your exam? Can you repeat your answer?
No.
Oh, was there any promises being made that got you to want to waive your exam today?
No.
Okay, you're waiving it freely and voluntarily?
Yes.
Okay, I'll bind the matter over to the circuit court for a bind over date of September 28th. That's not a date, however, that you need to appear in court. That's a date that the circuit court gets the file from this court. They'll set your next court date. It will be a pre-trial in circuit court. Mr. Goodrich will be made aware of that date and he'll be in contact with you, okay?
Okay.
Do you have any questions at this time?
No, ma'am.
Bond was set at 3,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing for the people.
No, Your Honor. Thank you.
You're all set, sir.
Your Honor, if we may call the Jessica Long case.
Mr. Kelly, you're free to go.
Okay, thank you.
We're on the record in the matter of the people of the state of Michigan versus Jessica Lynn Long. This is file number 22-02285, council appearance.
Chris Martin for the people.
Fred Blackman on behalf of Ms. Long, she's walking up to the next thing.
Thank you. Can you start that fan on low for me? Today's the date that was set for preliminary examination. However, last week at the PCC, just want the fan on. You turn the fan on? Yes, please. Last week at the PCC, Mr. Blackman had just been retained and requested to treat today as a PCC. And so we would need to waive the timeline if we're going to proceed to exam. Is that what we're doing today?
That's correct, Your Honor.
That is correct.
Okay. And so, Ms. Wong, you have the statutory right to have a preliminary examination in the district court. You have the right to have that within 21 days of your arraignment. You were arraigned, it looks like, on the 28th. Of August, and your exam was set for today, September 15th, but due to the fact that you retained Mr. Blackman in that time frame, we pushed the time limits out for him to get discovery and be prepared to formulate a defense for you. So because of that, the court's gonna find good cause to waive the timeline and go beyond the 21 days and reset it for another date, okay? Yes. Do you have any questions? Okay. Is there anything else that we have to address on the record today?
Only to get a new date for our preliminary exam.
Okay.
Just September 29th and then.
Does that work for you?
September 29th, Your Honor.
Yes.
I can get the witnesses here by that date. Do you need time to get your
No,
stuff?
no, I'll get up to you. September 29th will be okay.
At 9 a.m.
That's fine, guys.
September, she said 28th or 29th? Okay, we'll set this matter for. I'm sorry, were we supposed to have a bench trial when we was there?
After 29th, nothing scheduled. There was something, we'll say to the bench trial, not even Saturday. That's all. I mean, that's already the next day. Sounds good.
Your Honor, I think Mr. Blackman had a suggestion.
Judge, the only thing I'm asking is that I'm getting some materials from my client that I want to forward to Chris. And Chris has got some other stuff for me, and maybe, I apologize, maybe take a little bit longer than that to do that, Judge. The problem is the next Thursday, I have cancers, sort of thing, but the next week, I don't have anything on that Thursday. I don't know if the court would want to go out that far, but.
You want to go a week after that is what you need?
So I think October 16th, is that what you're
No,
looking
the
at?
13th. 13th. Is that too long for the
I feel
court?
like I'm not gonna be here. October 15th. Yeah, I think I'm in a wedding. We can go a week after.
Plan? Or the, yeah, I don't have anything that day either.
I knew I saw a bench trial coming up.
That's the bench trial.
Yeah, I'm like, there's a bench trial coming up on a Thursday for some reason.
It's at 1:30. You want to schedule this one?
Oh, yeah, bench trial's at 1:30. We'll be done with this, right?
Yes.
Okay.
We can do October 20th at 9.
Are there other exams? Will there be exams set on that day?
The CCCs, and then we have a bench trial in the afternoon.
What about the Friday after that?
This exam.
That's a thing.
We do it on that day so that we're all on the same day. I just want to exam. No, it's a Friday the 20th. It's just the day. It's Friday.
Oh, I don't,
First.
I don't, if you want to do the
If he's
Friday.
available, I don't know.
Yeah, I am.
You're the one who's gonna have multiple exams.
I just
I
don't,
gotta be there
I want to
anyways.
try to keep the exams on one date if I can, so that we're not.
Sounds a little CD, right?
Just maybe if we do set up, maybe we won't have an exam.
Okay, what day are we doing now? October 21st then?
Yeah.
Friday, the 21st, when there's already other
At what
exams.
time?
8:30.
It's gonna be the 21st at 8:30.
Thank you very much.
No problem. We'll get you a copy of your notice to appear, ma'am. Do you have any questions today?
No, I don't. Thank you.
Okay, anything else for the record, council?
Oh, yeah.
Enough for me.
Okay, thank you.
10:21. Thanks, Brad.
Can I get this back to you at a later date?
No, you can have it.
All right, thank you. Here's the, what you find. I have 10:21.
Oh, Mr. Brown, are you ready to proceed, Mr. Brown?
Yes, ma'am.
Okay. So on the record in the matter, the people of the state of Michigan versus Jason Michael McCombs, file number is 22-01643 FY, council appearance.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Jason McCombs, who's standing to my right, Your Honor.
Thank you. How are you today, sir?
Well, Your Honor, how about yourself?
I really was talking to you crying. I saw you in the hallway.
No.
No, but I am doing well. Thank you for asking. How are you, sir?
I'm good. How are you, Your Honor?
I'm doing well. Today was the date that was scheduled for preliminary examination. My understanding is that there was an offer by the people for Mr. McCombs to plead guilty to added count of attempted resisting obstructing, which is a misdemeanor punishable with a maximum penalty of 1 year and or $1,000 in fines, and entry without permission under MCL 750.115A. That's a misdemeanor with a maximum penalty of 90 days and or $500 in fines. And the people would move to dismiss the balance at the time of plea. There's also a Killebrew agreement of no upfront jail at the time of sentencing. Is that accurate?
Yes, Your Honor.
Okay. Mr. McCombs, you want to accept that offer?
Yes, Your Honor.
Okay, please raise your right hand.
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. I have an advice of rights and plea information sheet here. It has today's date on it. There's a signature at the bottom. Is that your signature?
Yes, Your Honor.
Did you read this document?
I did read it, Your Honor. Yes.
And you understand each of the rights listed here?
Yes, Your Honor.
Do you have any questions about these rights?
No, Your Honor.
You understand, sir, that you have the right to proceed to a trial in this matter, and you can have a trial by jury or by judge?
I understand, Your Honor.
Okay, you understand that at the time of trial, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes, Your Honor.
You understand that you have the right to have the prosecution prove each element of the charges being brought against you, and that they have to prove each element beyond a reasonable doubt at trial.
I understand.
You understand that you have a right to remain silent at trial and not have silence be used against you.
Yes, Your Honor.
And you also understand that you have the right to see, hear, or question any of the witnesses the prosecution intends to call. You also have the right to call your own witnesses or present evidence at trial that you believe would further defense. You understand those rights?
Yes, Your Honor.
Wish to waive each of those rights today?
I do, Your Honor.
Is anybody threatening you to get you to waive those rights?
No, Your Honor.
Has anybody promised you anything that wasn't stated here on the record if you waive your right?
No, Your Honor.
Are you currently on probation or parole?
I am not, Your Honor.
Now, you understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you might put it on future job applications?
I understand, Your Honor.
You also understand that a guilty plea could result in a conviction that may have an impact on any immigration status that you may be seeking.
Yes, Your Honor.
Okay, you still want to waive your rights, understanding that?
I do, Your Honor.
There's a Killebrew agreement. That's agreement about how you're going to be sentenced. That agreement is between you, Mr. Feigelson, and Mr. Martin. I'm not a party to that agreement, okay?
Yes, Your
So that means that at the time of your sentencing, if I decide that I am going to deviate and sentence you to upfront jail time, bless you, I would then grant you the opportunity to withdraw your plea, okay?
Yes, Your Honor. Thank you.
No problem. And you're pleading guilty today because you believe you are guilty?
Yes, Your Honor.
As to the added count 4, of attempted resist and obstruct, how do you plead?
Guilty, Your Honor.
And as to the added count 5 of entry without permission, how do you plead?
Guilty, Your Honor.
Do you have a factual basis?
Yes, Your Honor. Mr. McCombs, I want to turn your attention back to June 20th of this year. Were you at 1020 River Street? Yes, Your Honor. Yes, sir. Sorry. No, you're good. And it's here in the city of Lansing, New County, state of Michigan. Yes, sir. And there was a business that was there. Is that correct? Yes. You don't work in that business. Is that correct? I do not. And you went into that business. Is that correct? Yes. And no one gave you permission to enter into that business. Is that correct? No, the business wasn't open to the public. Is that correct? It was not, sir. And while there, you came in contact with law enforcement. Is that correct? Yes, sir. And law enforcement wanted to speak with you. Is that correct? Yes, sir. You didn't cooperate and interfered with their ability to remove you from the premises. Is that correct? Yes, sir. Your Honor, I have no other questions for Mr.
Any questions, Mr. Martin?
No questions, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea, and I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing will be October 28th. at 8:30 in the morning. That can be via Zoom if all parties consent.
I believe we'll be here unless you have the ability to do Zoom sometimes.
I prefer in person, I can do Zoom if it's preferred.
No, it's up in person is completely fine, sir.
I prefer
I'll be here in
only.
person.
Thank you.
And I'll be most likely here in person.
Okay, very good. Prior to sentencing, you need to have a pre-sentence report done. So I'm going to have you go downstairs to the probation department. If you leave here, we'll get you a referral so that they can set you up for a pre-sentence investigation, okay?
Yes, Your Honor, thank you.
No problem. Do you have any questions today?
Not at this time, Your Honor.
Any
Thank you.
additional matters for the record, counsel?
Yes, just one, Your Honor. Mr. McCombs does have a GPS tether. Today, I do believe that was part of the pre-trial bond order when we were looking at some felony charges, Your Honor. I would ask that GPS tether be removed from Mr. McCombs today. Said no
Yeah.
violations.
The GPS tether will be ordered removed.
Thank you.
Any additional matters?
None from the people, Your
And
Honor.
from the defense, Your Honor.
You're all set.
Thank
Give
you,
it
Your
about a
Honor.
couple hours and get a hold of JST and we'll probably have to go out and drop it back off.
Yes, sir. Thank you. Thank you,
Thank you,
Your
Your
Honor.
Oh, no problem. I forgot to get that in there. Thank you.
Mr. Austin is here on the Jalen Mitchell matter. My understanding is that we have not heard from Mr. Mitchell today. That case was set at 8:30. It's now 9:20 in the morning.
Okay, we're on the record in the matter of the people of the state of Michigan versus Jalen Michael Mitchell, file number 22-02287. Council is here.
Just mark the people.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of and in the absence of Jalen Mitchell.
Thank you. Today was the date set for a preliminary examination. That examination was scheduled for 8:30 in the morning. It's currently 9:20. When was the last time you spoke to Mr. Mitchell?
Your Honor, last time I spoke with Mr. Mitchell was when he appeared last week, at probable cause conference on Zoom. I know I confirmed with him about the hearing for this week. It was in person, and I believe the court reminded him of the same. I spoke initially with Mr. Mitchell when he was in custody, serving out a sentence on another matter. I have subsequently tried to get in contact with Mr. Mitchell since last week. The number that I confirmed for him, the voicemail isn't set up, so I was not able to leave him a voice message. I got an email address from him, which he confirmed to me was his email address, and that would be a good way to contact him. I've sent him multiple emails, no response, hasn't bounced back to me. Checked finally to see if he was in custody somewhere else. Doesn't appear to be the case. Fortunately, Your Honor, I can't provide the court with anything further regarding his whereabouts or his intentions.
Okay, I'll issue a bench warrant bond forfeiture and we'll see if we can make contact with him. I will hold it for 48 hours since he did appear at his PCC. You did note here that he has 2 jobs, quite likely he overslept.
That's possible.
He probably will show up this afternoon. I don't know. If he does, we'll see if we can get it reset.
But other than that, Your Honor, the bench warrant will be held for 48 hours.
Yes,
All right, thank you, Judge.
thank you. Go back. Thank you.
Yeah.
That was the next
With
one.
the Tito Commission class.
Did we, Mr. Blackman, you have more than one? 6. Is this his?
Yes, Your Honor.
I don't know what the scribble is for a date, but just gotta put actual date on there. You can't scribble. You don't signature the date. They can unleash your hand so that you can sign, sir.
Signed it.
Can you unleash his hand, please? Okay. Thank you. On the record in the matter of the people of the state of Michigan versus Eric Thomas Latham, file number 22-02016 FY, council appearance.
Chris Martin.
Morning, Your Honor. Attorney Dirk, also public defender on behalf of Mr. Latham, who's seated to my right.
Thank you. And how are you, Mr. Latham?
Okay, how you doing?
I'm doing well, thank you. Today was the date that was set for a preliminary examination. My understanding is that there was an offer extended by the people to which the defendant intends to accept. Please state the offer for the record.
Yes, Your Honor. The offer we extended was for Mr. Latham to plead no contest to an added count of domestic violence involving both of his sons, Davion and Keyshawn Latham. My understanding is he wishes to move forward with that. Mr. Latham is a resident of Illinois and has some parole issues, federal parole issues out of Illinois, and I believe he'll also be asking for immediate sentencing.
Okay, this is going to be 2 counts of DV.
There's 1 count of DV charged as to both of the sons. So there will be 2 victims in 1 count.
Okay, and then we're dropping the habitual offender. Is that correct?
Those will be dropped, yeah, because it's a misdemeanor.
Okay, good. Okay. Counsel, that's a complete and accurate understanding of the offer.
Yes, Your Honor, thank you. And we are asking for immediate sentencing. Thank you, Your Honor.
Okay, and then Mr. Latham, you understand that offer?
I'm only, so all other charges got dropped.
The offer is to drop the other charges after you plead guilty to an added count of domestic violence.
Yes, Your Honor.
Okay, and you wish to accept that offer?
Yes, Your Honor.
Have let me have you raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
Okay, thank you. Put your hand down. I have an advice of rights of plea information sheet with today's date on it. That's your signature on there.
Yes, Your Honor.
Did you read this document?
Yes, Your Honor.
Do you understand the rights listed here? Do
Yes, Your Honor.
you have any questions about these rights?
No, Your Honor.
Okay. You understand that you have the right to proceed to trial in this matter?
Yes, Your Honor.
You have the right to have a trial by judge or by jury, and at the time of trial, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You have the right to question, see, and hear any of the witnesses that the prosecution intends to call at trial. You understand that?
Yes, Your Honor.
You have the right to call your own witnesses or present evidence that you believe would further a defense to the charge. Do you understand that?
Yes, Your Honor.
You have the right to have the prosecution prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. You understand that?
Yes, Your Honor.
Lastly, you have the right to remain silent at trial and not have silence be used against you. You understand that, right?
Yes, Your Honor.
You wish to waive all of those rights today?
Yes, Your Honor.
Anybody promising you anything to get you to waive those rights?
No, Your Honor.
Anybody threatening you to get you to waive those rights?
No, Your Honor.
Okay, and you are on parole, is that correct? Or,
Federal supervisor release.
okay, it's federal supervised release. And this is a no contest offer. What was the purpose of the no contest?
Your Honor, it is because the federal supervised release, he does have pending violations that would be the reason for the no contest.
Oh, okay. So he has a recollection of this incident? And he doesn't, he's,
Your Honor, it's the factual basis would also be hard for him to make because of intoxication.
Oh.
Strong intoxicated at the time, according to the report.
and there's no objection to a no contest plea, correct?
That's part of the agreement.
Thank you. Okay. As to the added count 3 of domestic violence, how do you plead, sir? Okay, I have a Lansing Police Department report dated for May 30th, 2022 at approximately 12:39 a.m. Officers and Lansing Fire Department reported to the area of 14, or reported that at the area of 1400 East Kalamazoo, City of Lansing, Ingham County, State of Michigan, there was an assault of some sort that took place. Officers looked over a Davion and is it Keyshawn or Kayshawn? Injuries, Keyshawn's injuries, that Davion reported that he had arrived to the park and exited the vehicle to unfasten a family member out of the car seat in the center of the vehicle. The victim indicated that he heard his father, identified as Eric Latham, speaking. The victim turned around and stated that Eric headbutted him in the nose. Victim had created distance and informed that his nose was bleeding after being struck by Eric in the nose. Davion indicated he could smell lots of alcohol on Eric's breath. The victim was unable to provide a statement on what Eric said during the incident. And it looks like there was injuries observed as to Davion. It appeared that he had swelling on the bridge of his nose and he had apparent heavy bleeding from his nose. There was also a statement from another victim, Keyshawn Latham, who stated that he witnessed Eric Latham strike Davion in the head and he ran over to defend his brother. Keyshawn indicated when he had approached Eric, he was pushed. Eric pushed his face really hard 3 times. Keyshawn was then punched in the face with a closed fist. Keyshawn had deep and wide cut on the top of his gums and swelling on the inside of his mouth. Any additional factual basis from the prosecution?
And just to be clear, I know that this is a plea to a 93-day misdemeanor. We understand that there is an element of domestic violence missing from this factual basis, namely they were occupants of the same household. However, we believe that the court has provided a sufficient factual basis to an aggravated assault or a child abuse tort, which is a 1 year. And so the lesser charge could be entered under that factual basis.
Thank you. Any objection to the factual basis?
Not to the factual basis, Your Honor, no.
If the court is satisfied, and I'll accept the no contest plea. I find a no contest plea appropriate under the circumstances of the federal supervised release, and additionally, due to the level of intoxication that likely would have caused inability to present a factual basis. I find your plea to be made freely, voluntarily, and intelligently. There is a request for immediate sentences. With sentencing, we do have the victims present in the court, so I will proceed with immediate sentencing. Did your victims want to make any statement?
Yes. My understanding is that no one would like to make a statement.
Thank you. You can proceed with the allocution.
Thank you, Your Honor. Your Honor, I talked to Mr. Latham about this, and obviously because he's played no contest and has a pending violation, I'm limited on what I can and will say. I would just ask the court to consider sentencing to time served or a minimum jail sentence. It's my understanding he has the pending violation for his federal supervision. I have talked to his federal defender there in Chicago, and he has confirmed that at a minimum, he has violations pending for leaving the state as well as for the new charges. Talking to Mr. Latham, and I think he's talked to the attorney since then. It appears that Mr. Latham believes that he would get a sentence of a minimum of 18 months incarceration, 18 to 24 months. That's for Mr. Latham. When I talked to Mr. Bishop, I did not ask about a recommendation, but I know Mr. Latham has talked to him since then. I know that Mr. Latham, since he is pleading no contest today, is somewhat taking responsibility. And he did mention to me that he didn't want his kids to have to testify. Because in a situation like this, the kids are the ones that get hurt most. And he didn't want to put them through any court proceedings where they would have to testify against him. So he would ask the court again just to consider minimum jail sentence or time served, so that he can go ahead and be transferred or go back to Chicago to take care of his pending violation. Thank you, Your Honor.
Thank you. I'm quite at a loss for words over this. For a family to have to come to court due to a violent action at the hands of the person who's supposed to be their protector and provider disturbs me at great length. But for the fact that you have federal charges, I can guarantee you I would be inclined to max you out on this matter. But it's not meaningful in this particular case because you got bigger issues waiting for you in Illinois. But I think you probably want to spend some time doing some serious soul searching while you're sitting on your timeout, because you're supposed to be a positive example to your sons, and you failed them. When you fail them, you also fail society. And so hopefully you'll take some time over this next minimum of 18 months or whatever you got going on in Illinois to get yourself together. And I'm going to pray that there'll be some reconciliation for the benefit of your children, not for your benefit. With that being said, the court will enter a sentence of fines and costs. There's a $75 crime victim right fee per statute that must be assessed, plus a $50 state minimum cost that also must be assessed. I will also assess a fine of $500. It will be referred to collections. You can make do with that however you feel fit when you're back in Illinois, and I'll have it referred to collections so that arrangements can be made appropriately. Do you have any questions today, sir? Okay. Any additional matters for the record, counsel?
None of the people.
No, Your Honor, thank you.
Thank you. You're all set.
Thank you, Your Honor.
Did you need this back or do you want me to shred it?
I try to get.
Okay, Ms. Houseford is here. I don't see Mr. Blackman though. Could someone email him or ask him to get on so he can? Mr. Gallen, we're just waiting for your attorney to log in. He did have to run over to the circuit court, so he's gonna log in just a moment, okay?
All right.
We're on the record in the matter of the people of the state of Michigan versus Haywood. I'm sorry, what's the first name?
I don't believe that's him, Your Honor. It needs to be brought up.
Oh, he's not here. He's in custody?
Yeah.
Oh, okay, we'll wait. Off the record. Ms. Houseful, Mr. Blackman drove you to circuit court, correct?
He dropped me off at my office, Your Honor, and then he was proceeding on to the annex.
Oh, okay, sounds good. Maybe they got some extensive security measures over there, I don't know.
I'm not
Yeah, it's
sure.
pretty secure environment.
Thanks. seated. Thank you. Okay. We're on the record in the matter of the people of the state of Michigan versus Dominic Gadlin. File number is 22-00428. FY council appearance.
Thank you, Your Honor. Aaron Housefield on behalf of the people.
Your Honor, Fred Blackman on behalf of the defendant.
Thank you. And Mr. Gadlin is present from the Michigan Department of Corrections via Zoom. Today was the date that was set for preliminary examination. My understanding is that there's an unconditional waiver of exam for this matter to be bound over to circuit court. Is that correct?
Yes, Your Honor. Thank you.
That is correct, Your Honor.
Okay. Was there an offer at all?
There was, Your Honor. The offer that will continue with the file to circuit court is that the defendant plead as charged with a Killebrew agreement to a 12-month county cap. And I will state, just for notice purposes, Your Honor, that pursuant to statute, the people believe that that will be likely consecutive and not concurrent.
Okay. Mr. Blackman, that's accurate.
That is accurate. I talked with my client on the phone earlier this week and he's agreed to waive and we will be accepting that offer up in circuit court.
Thank you. Okay, Mr. Gadlin, you understand that you have the right to proceed to preliminary examination here in the district court?
Yes, ma'am.
You understand that at the time of examination, you have the right to have the prosecution show that there's sufficient evidence that a crime was committed and sufficient evidence to charge you as the person who committed the crime?
Yes.
You wish to unconditionally waive your examination today?
Yes.
Is anybody threatening you to get you to waive your exam?
No.
Has anybody made any promises to you to get you to waive your exam?
No.
And you're waiving it freely and voluntarily?
Yes.
Okay, I will bind the matter over to the circuit court. The bind over date is September 28, 2022. That's the date they get the file from this court. Your next court date will be a pre-trial in circuit court. They will notice Mr. Blackman of that date and he'll be in contact with you, okay?
Yes.
Do you have any questions at this time?
No.
Okay, any additional matters for the record, counsel?
Nothing for the people. Thank you, Your Honor.
Nothing for the defendant, but Dominic, I'll be setting up a phone conference again in the very near future, okay?
All right.
All right. Thank you, Your Honor.
Well,
Thank you.
no problem. Who's that? Okay, I thought did they bring your guy? Okay. We're on the record in the matter of the people of the state of Michigan versus Graygrove Holmes Haywood. File number is 22-02243. FY council appearance.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Dwayne Sullivan from the Office of Public Defender on behalf of Gabriel Holmes Haywood, who is seated in a chair to my immediate right.
How are you, Mr. Holmes Haywood?
Right.
Okay. Today was the date that was scheduled for preliminary examination. My understanding, however, is that there's going to be a unconditional waiver. Is that correct?
That's correct, Your Honor.
That is correct, Your Honor.
The people are waiving as well.
Yes, Your Honor.
Was there an offer at all?
There was, Your Honor. The offer is for the defendant to plead guilty to counts 3, assault with a dangerous weapon, and count 4, misdemeanor domestic violence. In exchange, the remaining charges would be dismissed, and the people would agree not to pursue witness interference charges, contacts made prior to the plea.
Mr. Silverthorne?
I understand that the habitual offender that has been added to the complaint would also not be issued.
That is correct.
That would be a full complete statement, Your Honor.
Okay, Mr. Holmes Haywood, do you understand that you have a right to have a preliminary examination in the district court? You understand that the purpose of that examination is for the prosecution to put forth that there is sufficient evidence that a crime is committed and sufficient evidence to charge you with that crime. You understand that? You wish to waive that examination unconditionally today? So that means there will not be a hearing to put on any evidence at the district court stage. You understand that? Anybody threatening you to get you to waive your exam? Was there any promises made to you to get you to waive your exam? So you're waiving it freely and voluntarily? I'll bind the matter over to the circuit court. The bind over date is September 28th. You will not need to appear in court on September 28th. That's the date they get the file from this court. Your next court date is going to be a pretrial in circuit court. Unless for some reason your attorney files a motion in the circuit court indicating that you need another arraignment. Your pretrial date will be provided to Mr. Silverthorne. He'll be in contact with you about that, okay? Do you have any questions today, sir? Bond was set at 25,000 cash surety with GPS tether and victim notification. That will continue. Any additional matters for the record?
Not from the people.
Who would like to address bond, Your Honor? If I may?
You may.
I would note that I was actually present before Judge Buchanan when he was being arraigned on a prior charge that has since been dismissed. And he was informed by Judge Buchanan of this offense, and that he needed to surrender himself, as this court is where many defendants do not elect to do that, particularly they find out what the charges are. Mr. Holmes Haywood is not one of those persons. He did voluntarily surrender himself for arraignment, and he's been in jail since. He has a child in common with the victim in this case. He knows, and I made him well aware that he cannot have contact in direct, indirect, or in any form that he wants to support the child or his children, the children that he has in common with him. He's never failed to appear in the past. He does have one prior, it's not a conviction, it's an HYTA conviction, which he completed successfully. So he does what he's told, in other words. He does have the presumption of innocence. I would note that we were here 2 weeks ago to this date with an offense, and Ms. Mangum did not appear at that occasion. She has not appeared again today. Now, I understand that doesn't mean that the offense did not occur, and that does not mean they're not serious. It simply means that it lessens the chance of conviction down the road. For all of these reasons, we ask the court, if it cannot give him a PR bond, to at least moderate his bond in terms of the cash surety. At the time that he turned himself in voluntarily, he was under a child support order for one of his children, which he was paying faithfully. He was working through paper already and Carter staffing, making $15 an hour, often working more than 40 hours a week. That's what he wants to get out to do. And again, I have thoroughly gone over with him the fact that he cannot contact. He had made some phone calls in the jail prior to the head counsel. Those have not since counsel have not continued. And they were to persons not directly Ms. Mangum, but they appeared to be to another male. With that, Your Honor, I will leave it to the court's discretion.
Are the people going to respond?
Yes, Your Honor. Called his people, told them, tell the victims, don't come to court. Go to the police, get the charges dropped, and then once you're done with that, and I can get out, call the prosecutors and say you don't want to go forward. He told the victim, he told his people, tell the victim, don't be at her house on this date, on the 15th, and for the previous court date, so the cops can't find her. This appears to be I believe be a pattern, because he had no qualms about doing this, and he did appear to actually talk to the victim when he's speaking to the male, telling him what to tell her. Says, you know what, just put her on the phone. Hands over and tells her directly. Go to the police, get them to drop the charges. Call the prosecutors, get them to drop the charges. I believe the bond is fair where it is. These are serious charges. He is alleged to have strangled the victim at least 6 times during this incident, after he took away her phone and her money that she still never got back. I think that it is an appropriate bond, and I ask that the bond remain where it is. Thank you.
And as it stands, the defendant is charged with 4 counts. One is assault with intent to do great bodily harm, less than murder, or by strangulation. Facing up to 10 years, $5,000. There's a count 2 larceny from a person. Count 3 assault with a dangerous weapon, also known as felonious assault, with using a handgun. Felony 4 years. The larceny from a person, felony 10 years. And then there's a count 4 of domestic violence that's being charged as a second offense known as with an enhanced penalty. A bond was set by the magistrate back on August 29th, about 2 weeks ago, 25,000 cash surety. And now it appears there's some allegations of witness interference, and that would also constitute a violation of the no contact order, which means that if true, Mr. Holmes Haywood actually doesn't do what he's told. So I'm going to deny the bond motion, and bond will continue as is. Any additional matters for the record?
Not from the people, Your Honor.
None for the defendant, Your Honor. Thank you.
Off the record. I think that's all we have for the morning. Let's see. There's a lot of in custody. Well, no, there's 3 in custody. PCCs. Right. So Thorns is continued, so we don't have to worry about that, correct?
Silverthorns is a leave on.
Continue the exam, so I'll cross that one out. And then, sir, which matter were you waiting on? Which matter is he waiting on?
What are you here for, sir?
Cody Shelton, is that? Oh, that was on Tuesday. It's a Tuesday case. Cody Shelton, that was a Tuesday case of the plea with Ms. Donnelly, he's the attorney.
I don't think he did. He didn't tell me.
He's in court right now.
Oh, that's Cody Shelton?
I believe so.
Oh. Let's see if we can find the file.
This is a matter for next week that I do not believe we should proceed on.
Yeah, all right, thank you.
All right, thanks, bud.
Uh-oh. What's happening here?
See you, Dwayne. So, did I talk to you about the motion to suppress that Sarah filed? Yeah, it was interesting. I'm gonna dismiss the case, not because of the motion to suppress, but because I think that the 911 caller basically admitted that they lied about the guy, their roommate being a trespasser, to get the cops to come and bust him. And it just felt so like.
This is
so
Cody
yucky,
Ryan,
because
correct?
they're all involved.
Cody Shelton. Oh, who's this attorney?
So, you know, it leads to an exigent search and search, which is already like, an exigent search. Which is already kind of like, you know, they're doing
Is it
it,
Donnelly
they're doing an
or
exigent search.
Goodrich? I'm trying to look through this. Well,
And
if
they
it's
find the
a
trespass.
thing, it's
but
Donnelly.
It's not trespass.
It could be Goodrich. He's on Monday. Well,
I think you
Goodrich
could
is on
probably-
our city.
Oh,
And then
okay.
Donnelly's on-
I would feel.
Okay. So should we-
Set up, and these are
You
all.
can let her know that he's
I would
here.
just reset it.
He's gotta be arraigned, but
Those are
you can let her, can you email her and tell her he's here.
Promulgated policy, which is. They found the pencil. Why? Like, they
On the record in the matter of the people of the state of Michigan versus Cody Sheldon, file number is 21-02525 SM. Mr. Sheldon, we have a warrant, bench warrant here, because you were supposed to be in person for the court. Back on the 6th, nope, on the 13th, it looks like. On the 13th, so earlier this week you were supposed to appear, then you did not appear. Did you-
13th, I thought it was the 15th.
No, it was the 13th at 10 a.m.
That's what I got wrote on the calendar.
We gave you a notice to appear. It said the 13th on it at 10 a.m.
We tried video chatting and
Yeah, he did, on the 6th, he couldn't get the video to work. That's why we reset it for him to come in person on the 13th. Yep, because he couldn't get the video to work. So what I'm gonna do, because you came today, is I'm gonna quash the warrant and give you a new date, okay? Does your attorney have your number? Because I think that might be part of the problem too. I think she tried to reach out.
I think she has 6080 number.
Okay, what's the new contact number?
517-541-6080 or 517-588-8850.
You get both of them? Okay, can you send them to, yes, Donnelly? Very good. Okay, we'll make sure your attorney has those, because what will happen is if you forget again, she likes to try to call to avoid the bench warrants. And then we'll reset your court date right now and give you a new notice, okay?
It was September 27th at 10 a.m.
September 27th at 10 a.m. Absolutely. Do you have any questions today, sir? Okay, you can have a seat. We'll get you a copy of your notice, okay?
Okay, thank you.
No problem. Is Cody Ryan with or without prejudice?
I'm going to say without for the time being.
Oh, sounds good.
It appears that the whole thing is based on a ruse, but you never know.
Sounds good.